Hello, I'm DRoger, General Counsel for the Las Vegas Police Protective Association. I'd like to update our videos concerning demanding identification from driver and passengers. So here is what has been clear for quite some time. When you have reasonable suspicion to pull over a driver, or for that matter, probable cause to believe that the driver has committed a traffic infraction, you have the right pursuant to statute to demand identification from the driver. You have to ask for proof of insurance as well as registration. That is clear. You may conduct just a regular records check on the driver. All that is clear. You may order the driver and passengers out of the vehicle, and you can detain the passengers. We have also talked about in the past how you may ask passengers for their identification. What has been unclear is whether you may demand identification from the passengers. Our Nevada statute provides that you may demand identification from someone when you have reasonable suspicion to believe that they have committed a crime. But on the other hand, when you have passengers in the vehicle who have not committed a crime, the question has been, may you demand identification? And understand that there's a distinction between asking for identification and demanding identification. You can always ask for identification. And then superimposed on that is that you may not unreasonably delay the stop. And so you have to move forward with the reason for the stop, and you have a reasonable period of time to finish your investigation concerning the stop, and at no time may you exceed the 1 hour limit. Now, the case of United States versus Landros, a 913 Federal 3rd 862, a Ninth Circuit Court of Appeals decision, which is controlling in this jurisdiction. In that case, the Ninth Circuit Court of Appeals held that an Arizona statute similar to ours does not allow an officer to demand identification from passengers when they don't have reasonable suspicion to believe that the passengers have committed any crimes. And so the Ninth Circuit case, which addressed the Arizona statute, will be controlling on us. And so with respect to that particular case, you may not demand identification from passengers when you don't have reasonable suspicion to believe that they have committed a crime. Now, of course, there are ways that you might be able to work around it. You ask the driver what the passengers' names are, and then you ask the passenger, you have them separate, and you ask them, and they give you a different name, then you may be able to extend the investigation to investigate providing false information to a police officer. But unless you have those extenuating circumstances, you may not demand identification from the passenger. That's the Ninth Circuit Court of Appeals case, and I'll provide that with our email. What is probably more troubling is a case in which Metro officers are defendants. This case was decided by Judge Boulware, who is a federal appointee. He was a former NAACP lawyer and did some work for the ACLU, I believe. And he ruled against the officers and Metro. And let's talk a little bit about the facts of this case, because this is important. This is Matthews versus Metro. Officer Justin Briers, Richard Nelson, Jonathan Carrington, and Lucas Ferris. And I believe one of them are sergeants. And so here's the factual scenario. One of the officers pulled over a van for traffic violations, went up to the driver and found that there were 10 passengers in the van, and they indicated that they were going to a Mongols meeting. And so the officer called for backup, got identification from the driver, and asked the passengers for their identification. They voluntarily gave over the identifications, and the officers began running records checks on these individuals. Subsequently, they filed a federal civil rights lawsuit, and the major issue in the case was whether the officers unreasonably lengthened the detention by taking, I think, 15 or 20 minutes to run all 10 individuals for records checks. And this is what the court had to say, which is troubling. He cited a case, and the quote was, "Because addressing the infraction is the purpose of the stop, it may last no longer than is necessary to effectuate that purpose. Authority for seizure thus ends when tasks tied to the traffic infraction are or reasonably should have been completed." The court finds that the undisputed facts establish that the traffic stop was unlawfully extended by the officers when they decided to collect and run background checks on all passengers in the vehicle. And so he found that the stop was unreasonably delayed because even though the passengers gave up their identification and the officers didn't have to demand it, they did it voluntarily, so to speak, running records checks on 10 individuals unreasonably extended the duration of the stop, which was unconstitutional. Now here is kind of the kicker for you. One of the arguments that the attorneys for Metro and the officers made was that these are individuals who are presumably Mongol members. It was important for the safety of the officers to run records checks. Obviously, you want to know who you're dealing with. You want to know whether an individual is wanted for murder or has warrants. And this is what the court wrote. "Moreover, the checking of the IDs did not enhance the safety or security of the officers on the scene. As the court has found, the occupants did not exhibit any threatening behavior or making any threatening or aggressive statements. Quite the contrary, it is undisputed that the occupants had an amicable approach to the officers and even joked with them at times." As the Ninth Circuit concluded in a case that I'll include with the cite later, checking for IDs for other information, possibly other crimes, does not enhance officer safety. The court agrees with the Ninth Circuit in Evans when it found that such investigatory checks are in fact inversely related to officer safety, as these checks extend the stop beyond its general duration and thus expose the officers to greater risk. And so after the court found that the stop was unconstitutional and that the officer's safety was not at stake, the question became whether the officers would receive qualified immunity. And qualified immunity means that you don't have to stand trial at all. You're just dismissed out of the case. And Judge Boulware concluded that the officers were not entitled to qualified immunity, and so therefore the case will move forward to trial, and these officers will have to face a jury as defendants. Folks, this is bad, and this is just another reason why you really have to rethink your stops. And so in a case like this, at least according to Judge Boulware, the officer should have written the ticket for the driver and let everybody go. And so maybe the officer should have said, "Hey, passengers in the back, relax. I'm not asking you for identification. I'm not going to detain you any further. I'm just going to write your driver a ticket and everybody goes." And maybe, at least from the court's perspective, the officers would not be in any safety, at any safety risk at all, because the passengers would not believe that they might be arrested for warrants or other things. So that is the state of law today on identifying passengers. Don't do it. The Ninth Circuit has held that our statute does not allow you to demand identification when there's no reasonable suspicion to believe that the passengers have committed crimes. And if you're going to ask for identification, run a quick records check, because otherwise you're going to end up in federal court. It pains me to do these videos. I've been a prosecutor and your attorney for 35 years now. It's not in my DNA to tell you not to do things, but you know, you have to protect yourself and your livelihood. Your family, maybe even relatives rely on your salary and your financial help, and not quite sure what else to say, but hang in there. We are doing our very best to protect your rights, and you know, my job is to make sure that you understand policy and that you don't get sued in federal court and lose your career. Thank you.
111, 110.